Recording in progress.
One second, please. Good day, Mr. Daniels.
Good day. How are you? What was Mrs. Aswood?
Yes, all is well, thank you.
I did send my clients the link, so I do anticipate that they may see one.
God. Thank you, Jesus. Yeah. I just made it down to the mic. Okay, right. Okay, now.
Mr. Creary, can you just mute your microphone? There might be a little button that says mute, but if I can invite you just to mute,
Mute it. Okay.
because you're not going to be able to address the court. Thank you.
Good afternoon, my lady.
Yes, good afternoon, everyone. Thank you. We'll have Ms. Oswald read out the heading. Friday, the 9th day of July, 2021, called via Zoom at 2:34 p.m. before the Honorable Justice Sibyl Williams, Appellate Jurisdiction 2020, number 32. Dwayne Creary versus Fiona Miller, Police Sergeant. Mr. Mark Daniels for the appellate, Mr. Javon Rogers for the respondent. Okay, good afternoon, everyone.
Good afternoon, my lady.
I can see that we have who I presume to be Mr. Creary. Yes, okay, thank you. He's muted, but that's fine, thank you. And you're muted, Mr. You're muted.
Forgive me, I thought I had unmuted myself and
Yes, that's
I'm
fine.
off. Okay.
Okay.
Yes, if it pleases your ladyship.
Mhm.
Effectively, if I can just talk in the round and just bring the court up to speed in terms of the nature of the case, we filed an application for leave for notice to appeal against the sentence that was imposed by the worshipful magistrate Tukumbo following a contested trial where the appellant was found guilty, and we don't seek to challenge the finding of guilt. In summary, what I would like to do is just set out what I would consider a good synopsis of the case, which is set out in my written submissions. But effectively, my client, the appellant, was convicted of 2 counts of causing GBH by driving a motor car without due care and attention pursuant to Section 37A of the Road Traffic Act, my lady.
Yes.
And what we can see when you glean through the judgments, if your ladyship has had an opportunity to go through the judgments of his worship, which is set out on pages 19 to 24, of the record, effectively, what I would submit to the court is that there are inferences that the court could have and did in fact reasonably draw from the facts. And that would be, one, that the appellant had either had some momentary inattention due to his lack of sleep the night prior, or two, the appellant actually dozed off while he was driving, which would be a question of degree. Now, the appellant did not admit to falling asleep while driving, but he did accept that he had no knowledge or recollection of the events after certain points en route. So basically, he had passed Modern Martin Paget, the Bermuda College, and then just as I guess he would have approached the Elbow Beach, he started to lose recollection of what transpired thereafter. And if I could just take a moment to invite you to look at page 22 of the record, my lady. You'll see at the very top of that page, if I can invite you just to look there.
Yes.
It says, I do not accept the subsequent evidence of the defendant or believe he was being honest when he says he was feeling good / fine during all driving times. And it continues to say, this was a veiled attempt to nullify his statement of P.C. Evans when first taxed. And I find and accept that at the material time of the collision, the road was wet and oily in the westbound and eastbound lanes, and the road was relatively flat in a straight stretch with no apparent need for harsh / hard braking or steering. And then he continues to say, which is what's important, I find that the defendant was indeed quite fatigued, notwithstanding he worked the 2 a.m. to 7 a.m. shift on the weekends for some 6 years. He ought reasonably to have known not to drive when fatigued or to pull the vehicle to the roadside safely to rest. That is what any reasonable or prudent driver would have done. And so I paused there momentarily. Of course, he makes reference to certain law, but that is I think it encapsulates the findings of the court down below, which would have led to the ultimate sentence that was imposed. And so I think what's also important for the court to have in mind when looking at an issue on sentence of this nature is to have regard to the medical evidence that exists in the case. And in that regard, I believe that it's at page 84 of the record that my lady will see medical evidence that was adduced and relied upon at trial. And if I may,
Page 84?
Yes.
The statement of,
Sorry.
oh, I see, just before it.
Forgive me. I think it's just before that, forgive me. I think I used...
Is it the
yes,
hospital record you're referring to?
Correct, my lady, my apologies. I'm just, that should say
Philip
page
Jones.
79. I see at the top discharge. So first I was going to look at, if I may, I was going to deal with Shanita Furbit first, and then go on, because she was the rider, and then go on to Alizé. So it's actually at page 83. You'll see the Bermuda Hospitals Board document signed by Philip Jones, MD.
Yes.
And in that, just to give the context for the background of the court, you'll see that there, in the second paragraph, the first complainant had suffered a deformity to the right thigh with a large wound to the front of the knee.
Yes.
And that there was also a traumatic amputation of her right big toe partway down. Further, she had suffered some tenderness to her lower abdomen. And there were fractures of the shaft of the right femur, which is the thigh bone, as well as fractures of the pelvis.
Mm-hmm.
And then she was discharged and treated with painkillers and antibiotics. So I just wanted to highlight.
Yes.
Forgive me, I thought I froze for a moment. I just wanted to highlight, in respect of the first victim in this case, the extent of the injuries, and just make sure that they're relevant to the court's attention before addressing your ladyship in respective aspects of law. And the second is going to be borne out on page, what I was incorrectly stating, but page 79 to 80 primarily, which concerns the rider of that vehicle.
Can I just stop you there, please, Mr.
Absolutely.
Daniels?
Yes, my lady.
I'm about to make a statement which has general application. I usually find it helpful for people to just start with their notices of appeal. It gives me some context as to what, so that everything you're saying to me is somewhat being received in abstract, because I don't know what you want me to take from the passages that you're highlighting. Like, where are you?
Certainly.
So I'm looking at page 3.
So page 3 of the record,
Mm-hmm.
the singular ground of appeal, and I'll just read the quote, is that the learned sentencing magistrate erred in law by imposing a sentence that was not proportionate with the circumstances of this particular case,
Right.
and which is manifestly harsh and
Okay.
excessive.
So you're only
And the
challenging
particular
the
context-
sentence.
So I'm only challenging the sentence, and I thought I made that clear.
You
from the
might
outset,
have, I'm
but
sorry.
Forgive me, my lady. No, I might be speaking quickly, or the connection might not be as clear, so I'll try to take it a little slower.
Yeah.
But this is an appeal, strictly speaking, in relation to the sentence. And the sentence that was imposed, you'll see from page 19 of the record is the
Yes.
judgment that sets out, if I can just take you to page 19 very briefly. The defendant is charged with 2 counts of causing grievous bodily harm to 2 persons by driving on South Road without due care and attention for other persons using the road on 1/7/2018 in Paget Parish.
Mhm.
And the prosecution evidence, unchallenged by the defendant, is that his vehicle strayed across the yellow center line from his westbound lane and directly into the opposing eastbound lane, colliding with the 2 complainants who were correctly traveling in their eastbound lane. And just to make it clear, there was 1 motorcycle that was ridden by the 2 complainants, and one was the rider, one was the passenger, just to make that clear.
Okay.
And the collision resulted in extensive damage to the complainant's vehicle and multiple injuries to the complainants, which amounted to grievous bodily harm,
Right.
which I think we've just set out, at least in relation to the rider.
Okay.
And so without reading through the entirety of it, what we'll see is, with respect to the sentence that was ultimately passed, that features in relation to pages 23 and 24.
Is it that he
Of the
got
record.
2.5 years, 2 sentences that ran consecutively, 2.5 years disqualification? I think the Crown has accepted that that was beyond what the magistrate had the statutory power to do.
That's correct.
Right.
So in summary, looking at those particular points, the first grounds that we take in relation to the disqualification period, if I may,
Right.
is that, and if we go to Section 37A of the Road Traffic Act, and then consider the Traffic Offenses Penalties Act, under those statutory headings, when it comes down to a Section 37A offense,
Mhm.
if it's the first offense, which is applicable to this particular appellant, there's a maximum fine of $3,000 or 3 years imprisonment, or both.
Mhm.
That's under head 5, my lady.
Thank you.
And under head 6, for a first offense, there's an obligatory period of 2 years disqualification, which again, we say applies. And effectively, what we sought to advance in the trial down below was that the sentence to be imposed and the period of disqualification should both run concurrent and not consecutive. And that's the starting point that we raise our grievance with. What I concede is that I'm thankful for the Crown acknowledging this in their submissions in reply at paragraph 6, I believe, is they concede that the 2.5-year period of disqualification would be unlawful because it exceeds the statutory period.
Of 4 years on the first offense.
It's 2 years on the first offense in a summary jurisdiction.
Oh, I see.
This case was dealt with summarily.
Yeah.
And so where the statute provides a maximum of 2 years disqualification, and bearing in mind that Section 4 of the Act also contemplates 4 offenses, and I'll come to later, which do not concern impairment or of alcohol or drug, there is scope for a sentencing magistrate, when looking at periods of disqualification, to look at other mechanisms, such as if a car was used, as was in this case, to perhaps enable an individual to use a motorcycle or not. And those were matters that equally could have been taken into account down below, but which were not.
Okay.
And so,
Sorry, let me just take you back a moment, Mr.
Yes.
Daniels. I'm looking at head 5,
yes,
and I'm obviously not concerned with causing death, causing grievous bodily harm under head 5. What I see in front of me is if first offense 4 years, if second offense 7 years, if third offense 9 years. causing grievous bodily harm summary offense, the first offense is $3,000 or 3 years of both. That's what you're referring to?
Yes, that's what I read out to the court.
Okay. You need to slow
Yes.
down, Mr.
Forgive me, my lady.
Daniels, please.
Forgive me.
I'm not so quick anymore.
It's also, I know with the computer systems, it's hard to assess, and
Yes.
apologies, I feel a little rusty this way.
Okay. First offense, 3,000 or 3 years. Now, help me to understand, where is the bridge and where is the disconnect between you and the Crown? Because the Crown accepts, obviously, that the court didn't have the power to do 2.5 years consecutive on two to come to a total of 5 years. Is it agreed that it should just be reduced accordingly, or do you have some discord between you as to how much?
I must confess, I only received the submissions yesterday from my learned friend. I didn't have an opportunity in my schedule to liaise further with him.
Why were
But my
submissions sent
understanding,
so late?
I will yield to my learned friend to clarify.
Well, I'll let I gave directions for this, I assume.
Yes, my lady.
Is this one of those files that was relisted because of the court closures?
That is correct.
Yeah.
When did I get directions? I don't see my notes on the file for directions.
As I understood it, my lady, the submissions were to be filed 4 days prior to
the hearing.
Yeah, I actually served and filed it on Wednesday.
Okay, so there was no late filing of submissions. Is that the bottom line?
It was, my lady, by I think 2 days, but I did indicate to my friend what the Crown's position as to we weren't taking an issue with either the period of the disqualification being consecutive, or in fact the period itself. The period, the 2.5 years, which was issued for disqualification, was longer than the statutory obligated 2 years.
Yes.
And we accept that. And we also accept that it shouldn't have been consecutive.
Yes, that I understood. Mr. Daniels, what are you suggesting that would have been the appropriate course for the magistrate to have taken in terms of disqualification? I just want to get to the point. This is not something that we need to belabor unnecessarily, but what are you saying should have been passed by way of sentence in terms of disqualification?
So because of the severity of the injuries, I can accept and concede that even at the conclusion of a trial, that imposing something close to the maximum, for example, an 18-month period of disqualification, forgive me, the 2-year period of disqualification, because it's obligatory, there's no challenge in the disqualification period. However,
Right.
My position has always been that it should be concurrent and not consecutive. And I'm grateful that the Crown agreed to that.
So you
And
are
so then
happy
that-
so I don't need to be troubled on this. If that's what
So you
I just want to understand, or obviously I have to take a view, but
Yes,
I don't need to hear any lengthy arguments on this. It seems to me that it's agreed between the Crown and the defense that the proper course would have been just to make the sentences concurrent in terms of the disqualification.
correct. And then
Yes?
with respect to the fine, my respectful
Okay.
submission is
All right, so sorry,
In terms of the
is that
disqualification.
it for the disqualification?
yes.
You know what is happening? I think there's a technical issue. I do think your frame is freezing somewhat, Mr. Daniels, and it's
Yes.
giving unfortunately, it's discontorting the pace of this exchange.
My lady, perhaps what I can do is if I can log in from a phone as opposed to using the Wi-Fi, if that gives it a better quality, I can try and do that.
Let's leave it for now.
Okay,
If it gets much worse, I mean, I can see what's happening now, but let's just see how far we get with this first.
Okay.
So disqualification, should have been concurrent. And let's, can you take me, before we leave the point of disqualification, can you take me to the information? I see it, page 6 of the record.
Yes,
Notwithstanding the Crohn's agreement, are you saying that, oh, maybe actually what I should first ask you is to help me to understand why there are 2 charges here.
because there was a rider and a passenger. So there was a mother and son traveling together on one motorcycle. And so the appellant's vehicle crossed the center yellow line, crashed into that motorcycle,
Because the
and caused
injury
injury to
involves
2
2 different
persons
people, is that
traveling
it?
on the same vehicle.
So the 2 charges
Correct,
is only there to reflect that there were 2 complainants
correct,
and the complainants were on the same vehicle.
correct.
Strange way to deal with the charging, isn't it, Mr. Rogers? Can you help me to understand why?
My lady, I believe that it's actually necessary when we do have the 2 people injured in such a way, because the court can come to the conclusion that one of the persons were injured to the extent of grievous bodily harm, but
see.
the other wasn't. So we would still have to have both on.
Separated.
Yes, my lady.
Let me ask you this question, Mr. Daniels, and I may go between the 2 of you on this because I'm only dealing with the disqualification, and
Absolutely.
you don't seem to be in any sort of adversarial position on this. Suppose for a moment that in causing the accident, the appellant had in fact struck 2 different vehicles and injury had been sustained, grievous bodily harm had been sustained by passengers on both vehicles.
Yes.
What would be the powers of the court in terms of disqualification?
It would be the same, my lady. And
So the
this is
court would
where,
be bound by this first offense of 4 years? Sorry, I keep saying 4 years, 3 years?
2 years, 2 years, my lady. 2 years,
My lady.
3,000 is the maximum.
My lady, I may be able to assist in relation to that if the court does have the Traffic Offenses Penalties Act in front
I
of it.
do, and I keep, so I'm looking at head 5, causing grievous bodily harm in relation to summary offenses, if first
Yes.
offense, 3,000 or 3 years or both.
Yes, that's the penalty, and then head 6 is the disqualification period.
Oh, I see, I'm looking at the wrong head.
Yes,
Yeah.
my lady.
Oh, I thought you had told me to look at head 5, sorry.
Well, head 5 was in terms of the fine. So
Oh, I
when you
see.
look at head 5, you'll see that there is under causing grievous bodily harm
Okay.
in
That's
brackets.
all right, I see,
summary.
I'm under head 6 now, that's fine. So
Okay.
3 years, let me, and I think, in fact, you didn't wrongly noted that.
But my lady, in relation to the disqualification point
Mhm.
that you asked, in
Yeah.
if there were 2 separate vehicles,
Yes,
the reason why the Crown has conceded this point is due to Section 6 of the Traffic Offenses Penalties Act,
mhm.
which is before the schedule,
All
which
right.
reads,
One moment, let me, just give me a second, because I want to read that alongside your reference. One moment. All right. So now I'm looking at section 6, you said?
Yes, my lady.
All right. Let's see.
Which deals with the period of disqualification.
Mm-hmm.
And it reads, where a person is disqualified by an order of the court under this act, the period of disqualification shall, subject to subsection 2, commence on the date of conviction. And subsection 2 is where a person is disqualified at the date of commission of the traffic offense. Any period of disqualification ordered by the court on his conviction of that offense shall commence on the date of his conviction. So even if there were two vehicles which were struck, the disqualification period itself has to start on the date of the conviction.
But the court always has, so what are the court's powers then in terms of making a sentence consecutive or concurrent to another conviction before the court?
My lady, what it looks like is that the period of disqualification cannot be consecutive. Because it seems to be clear that the commencement date of the disqualification is the date of conviction.
You're asking me, I appreciate that this isn't a great position, but it's an important point. And it's a point that I think has to be decided correctly. So I'm afraid that you're going to have to refer me to the provisions, which I believe are in the criminal code, which deal with the court's power of sentencing and proportionality and all of the law that we've heard about the court deciding on the proportionality of a sentence. That being said, we're obviously looking at the magistrate's powers as well, which are statutory. But I'm afraid you'll have to persuade me a little further before we can move on from disqualification, because I am quite conscious of the fact that if I decide in favor of the submission before me, it's going to set a precedent.
Yes, my lady.
So let's look at it a little bit more closely, I think.
My lady, did you receive the authority of noble,
Um,
which is referred to in paragraph 34 of my submissions in tandem with my submissions, the hard copy?
see, I don't.
It's a Court of Appeal
For
authority.
me, the Court of Appeal?
No, it's a UK Court of Appeal case. Citation 2002 EWCA Crim
You filed it in hard
1713.
copy? Mr. Daniels, you filed it in hard
It should
copy?
have been filed in hard copy with the submissions. When I sent my,
Or did you, if you can, if
I
you send
believe
it by
so,
email, I
lady.
might be able to pull it up now, but I'm just trying to see what's the quickest way to get my hands
no,
on it.
because when I sent the email, I sent the email prior to the shutdown that we had. So
Right.
it only contained the submissions, but when I was able to send the hard copy over, I believe the submissions and the authorities were sent together.
And it's obviously not part of the record. There are authorities, for example, that I see have been included in the record from page 109.
Page 109. No, the record would not have had, no, these submissions were not advanced down below.
Okay,
They
Well, then
were
no, I don't
appeal
have it.
submissions. I'm guided, my lady. Okay, while I'm just trying to tee that up, if I can just confirm that it would be supremecort@gov.bm
yes,
is the appropriate email address to try and send this to your attention right now.
okay. I know that we were having technical difficulties yesterday, so I hope that's
Okay,
not
my
going
lady.
to prevent me from seeing it now. 1 moment.
What I can do, my lady, in any event, is at the conclusion, obviously, I would prefer to have everything dealt with in one go, but I can undertake, depending on what time we finish, to provide the copies to the court this afternoon, if they would accept me, if not Monday morning. But if I may, the first authority that I would invite the
You
court to
can send
consider
it by
is the
email,
court.
Mr. Daniels. You can send it by email, even if it's after the hearing and you can't locate it. No, I can. receive
Yeah,
it
so I
by
have
email.
sent Noble. I have sent Noble just now
All right, just one minute. Let me
from
look.
one of my devices.
Yep, I see it. All right, yes. I have Noble in front of me. Are we gonna look at it now or later? Mr. Daniels?
Yes, my lady, I think it froze for a moment. I was just waiting to get back live. Do you have Noble to your computer, at least at the moment?
I have Noble in front of me. I was asking whether or not we're going to look at that now or later, because you interjected to refer me to Noble.
Yes, my lady. I was just trying to give some assistance from a common law perspective. That this was a case that concerned consecutive sentences. You'll see from the head note. It's
Okay.
not a careless driving case. It's actually more egregious. It concerns causing death by dangerous driving.
Yes,
It says multiple deaths arising from the same act of dangerous driving, and whether
Yes.
appropriate to impose consecutive sentences.
yes.
And so if I go to paragraph H3,
Mhm.
it says that the appellant was convicted of 6 offenses of causing death by dangerous driving. The offenses arose out of a single incident. The appellant was driving a Land Cruiser at about 8:15 p.m. when he lost control of the vehicle, which veered across the road into a stone wall and then rebounded into the path of an oncoming vehicle. 3 people in the appellant's vehicle and 3 people in the oncoming vehicle were all killed. So just pausing momentarily, you were asking a question about multiple vehicles. And I appreciate that this one does involve the death of individuals in the appellant's vehicle as well as those of the victims.
Yes.
But the evidence demonstrated that the appellant and his friends had been drinking since about 1:30 in the afternoon on the same day. The appellant admitted to having drunk 12 pints of lager, 1 pint of mixed lager and cider, and 2 Bacardi breezers. There was evidence that shortly before the accident, the appellant was driving at excessive speed. After the accident, the appellant ran off across some fields and spent the night at his sister's home. He was arrested the following day and stated that another person had been driving the vehicle at the time of the accident. He provided a sample of breath, which gave a negative reading. On the basis of the appellant's own account of how much he had to drink, it was estimated that at the time of the accident, he would have had 155 milligrams of alcohol per 100 milliliters of blood. The appellant had twice previously been convicted of driving with excess alcohol and was disqualified from driving at the time of the offenses. He was sentenced to 5 years imprisonment on each of the first 3 counts, concurrent, and 10 years imprisonment on the other counts. Those terms concurrent with each other, but consecutive to the terms of 5 years imprisonment. The total sentence being 15 years imprisonment and disqualified from driving for life, and was held in those various cases that were cited. It was submitted on the appellant's behalf that the sentence of 15 years imprisonment was wrong in principle because consecutive sentences were not appropriate where all of the offenses arose out of the same incident, and that the total sentence was in any event excessive. This case appeared to involve the highest number of deaths arising from a single piece of dangerous driving. So that's emphasis added. It had many aggravating features, including the fact that the appellant had engaged on a mobile pub crawl and was well above the limit for alcohol in the blood. He had a very bad driving record. He was disqualified from driving at the time of the accident. He ran off after the accident and then blamed someone else. In his evidence, in the view of the trial judge, he had showed breathtaking arrogance with no compassion for his victims. It seemed to the court that the element of chance in the number of people killed by a single piece of dangerous driving underlined the appropriateness of the general principle which applied throughout sentencing for criminal offenses, namely that consecutive sentences should not normally be imposed for offenses arising out of the same incident. That was not an absolute principle. It might admit of exceptions in exceptional circumstances. Where such exceptional cases did occur, they tended to be cases where different offenses were committed. It seemed to the court wrong in principle to impose consecutive sentences in respect of each death arising from a single piece of dangerous driving. The court emphasized that it was right that the total sentence imposed in such cases should take account of the number of deaths involved. The fact that multiple deaths had been caused was not in itself a reason for imposing consecutive sentences. And the main focus of the sentencing judge in such cases had to be on the dangerousness of the driving, taking into account all the circumstances of that driving, including the results. In the present case, most of the aggravating features referred to in Boswell were present. There was no significant mitigation. The longest total sentence which the court could discover in the reported cases for causing death by dangerous driving had been 8 years imprisonment. In the court's judgment, the offense could probably be dealt with within the maximum sentence laid down by Parliament, which was 10 years imprisonment. This was a case which came at the very top of the range. It was difficult, realistically, to imagine a worse case. The court would therefore make all the sentences imposed concurrent, producing a total term of 10 years imprisonment, which in the court's view reflected the total criminality involved. The court considered this was one of those rare cases where disqualification from life was necessary to protect the public. And so that's where the exceptional circumstance came in relation to the period of disqualification. In our case, though, we're not talking about one of the worst pieces of driving experiences, and the reliance that we place on the particular authority is one, that the fact that there were two injured parties, both mother and son, arising in the same vehicle would still give credence to a concurrent period of disqualification being imposed.
Mm-hmm.
But even if there was another vehicle involved, whether it was individuals in the appellant's car, or dare I say, a second vehicle that was across the road that sustained some further damage as well, we still have to look at the criminality as the inference being drawn of tiredness or anything of that nature that caused the appellant to veer across the wrong side of the road, and that this is still a single incident. And so it'd be my respectful submission to this court that the Court of Appeal Authority of Noble would be of considerable persuasive weight, that only concurrent sentences should be considered in relation to the period of one, disqualification, but I would also then go further when we get to the point of the fines in relation to the fines. But using it for the purposes of the disqualification period, my humble submission to the court is that there is lawful authority to suggest that where there is a single incidence of bad driving, notwithstanding that there are multiple injured parties, the punishment of disqualification should remain the same. And that is buttressed by the statutory provisions set out in Section 6, which my learned friend made reference to.
Was the English Court of Appeal looking at similar statutory provision?
I don't believe that they.
That was similar to Section 6 for us?
No, I don't believe, because there's no reference that I could see in the judgment to any particular statutory provisions that we have or akin to what we have.
But even if it didn't, I think it's open to you to say that because of our Section 6,
Correct.
that would be the natural way for you to construe it. Number one, it's
Correct.
plain and clear on its face. So there's a literal interpretation that is open to you that Parliament intended for the period of disqualification to only run no matter how many victims may arise out of a single accident. The disqualification period should not exceed 2 years from the date of, you said the date of conviction or the date of the?
Date of conviction.
Conviction, yes.
Yes, date of conviction.
And so whatever the statutory position may be that the Court of Appeal was looking at, that would be the natural way for us to look at Section 6.1, applying those principles. That's what you would say, wouldn't it? Did
That
you
would
not
be
understand?
Yes, that would be my invitation to the court. Yes, my lady.
Okay. Sorry, I think we were having a pause again.
Yes. I started to lose you a little bit. I think I started to lose you, but I do follow the line of thought
Right.
we're going down.
Okay. I think that is very helpful in terms of, so I've just noticed Section 6. Disqualification. Maximum. And RV Noble.
My lady,
Why wasn't this brought to the attention of the learned magistrate?
well, I do believe that I asked that this should be dealt with concurrently. You'll see in my page 23,
Okay.
but I framed it, and it is correct in terms of the record. I framed it. I didn't have this case to hand at the material time.
Yeah.
But I framed it under the totality principle, and I concede that I did not make the point in relation to the section 6 reference on my feet.
Okay.
That only feature.
So the magistrate would not have been live to this particular point when he passed the sentence. So
That's
it's not
correct.
as if he had determined an argument on this.
No,
Okay. All right.
no, no. And so, if I may just invite your ladyship as well, there was a case, just doing some preparation in advance of today. Late last evening, I just wanted to kind of see if there was another local case that might provide some assistance. And I did come across a 1991 Court of Appeal authority, which is number 16 of 1991. I can undertake to send it to you, perhaps when my learned friend is addressing the court, my lady.
What's the name of
But
the
it's a case of Spence and the Queen. And this would have been before Roberts P. DaCosta J.A. and Henry J.A. It was a case where K. White was for the appellant and P. Calhoun was for the Crown. But in particular, there's a question. This was a case on robbery. And this was a case in relation to looking at issues of aggravating factors and previous convictions and whether or not concurrent and consecutive sentences should be approved. And it made reference to a case of Derek Herbert and the Queen, a UK authority, which talked about, and I can just read the quote, that the question arises as to whether concurrent or consecutive sentences should be imposed in circumstances of this nature. The matter was considered in Herbert and the Queen, in which this court expressed the view that where offenses take place at very different times, the sentences should be at least consecutive. But where there are circumstances, and that's obviously a standard principle of law, I think, but I just wanted to emphasize the point that I specifically wanted to see if there was any comparable Court of Appeal authority in relation to consecutive and concurrent sentences. And while I know it's somewhat trite and not on all fours because it's not a traffic case, my respectful submission is that there is authority in this jurisdiction that would assist this court.
You said you would send that case
I can send that to you
by email
momentarily.
as well? Okay,
I'll do that momentarily.
thank you.
And as I said, the reason why I wanted to touch upon the medical evidence, my lady, is because I want the court obviously to appreciate that there was a significant collision. But one of the factors when we move on to looking at the fine and some of the gravamen for it is that I can see how the extent of the injuries and the fact that this appellant proceeded to trial and was unsuccessful would certainly support a fine being imposed that was at the upper echelons. And so the context of 2.5 years in of itself as a fine, I do not think is disproportionate in any regard. The only issue that we would have taken with respect to the $2,500 fine is the fact that it was, again, made in relation to both counts. And my humble submission to the court is that when looking at periods of disqualification, the Crown has conceded that a concurrent sentence is appropriate. Now, if we pause momentarily, and I appreciate that this offense is one that can carry a maximum of a $3,000 fine and or imprisonment. But if we were looking at imprisonment, I do not think that the Crown would seek to argue that the imprisonment should be consecutive. And if I'm correct in that analysis, and I would yield to my learned friend, then I don't understand the narrative or basis upon which the Crown can forcefully argue that the fine should therefore fall into some special category that would attract a consecutive sentence when a period of imprisonment or a period of disqualification would not, as a matter of good law.
It's barred from doing that under one of the provisions, if I recall correctly. There's an express statutory provision that bars the Crown from seeking, or that bars the court from imposing both imprisonment and disqualification. Is that right?
I'm not entirely, I must confess, I'm not up to speed. Sorry, I lost you.
Okay,
I'm
well,
not-
I mean, it may not be the case.
It may not, but,
How
but
about, but does that mean I've now misunderstood you? So your point is that applying the principle that you've relied on in terms of the disqualification,
correct.
the same should apply insofar as a fine was
Fine.
imposed plus a disqualification?
So I have it's a statutory provision that the court must go through the various heads. And so when looking at head 5, the question that the court would always be asked to consider is, should I consider a fine? Or should I consider imprisonment? Or should I consider both? In
Mhm.
this instance, the court determined that a fine was appropriate. And I
Yes,
take no issue with that.
right.
The issue that I take is that the fine was applied in relation to count 1 and count 2, making the total amount higher or more excessive than what should have been imposed. My respectful submission to the court would have been that if the learned magistrate had said, I deem that this was a serious enough offense that warrants a maximum fine at the conclusion of a trial, and there was a $3,000 fine that was imposed, and that was it, I could take no material objection to that particular point. But when we look at page 24, and I just take you to the last paragraph, it says, I'm going to impose the mandatory disqualification of 2 years in each case and exercise my discretion to up it with 6 months, making it 2.5 years on each count consecutive to the other, and a fine $2,500 times 2. So if he imposed $3,000 on count
Reading
1,
about a
$3,000,
total of $5,000. Am I reading that
Yes.
correctly?
correct.
So you're saying that he should have just left it at 2,500 and applied that to both?
Or if he felt that because of the material facts in the case and all the circumstances that $3,000 was warranted, but he imposed $3,000 concurrently, then I don't think I could take material objection, nor would I come to court scribbling over $3,000 to $2,500. But the
Mhm.
fundamental impact to my client is that he's received 5 years off the road and a $5,000 fine, which on all fours, I would humbly submit to the court, is simply manifestly excessive and harsh in the circumstances.
Right.
So that's the crux of it. But by way of further background, what I also just wanted to update the court, and I did provide my learned friend with a copy of this, probably just as we were sitting down online.
Mhm.
My client has a magistrate's court costs and payment receipt, my lady. This is not going to be before your ladyship at this stage. I just received this on WhatsApp today, and then I forwarded it to my learned friend just to confirm if he could. And it's in relation to the case number 19TR04282, Regina and Dwayne Creary. And it shows that he has the 2 fines of $2,500, making a total of $5,000. And he's paid to date $2,900, leaving a balance of $2,100 payable. And so I just highlight that, notwithstanding the fact that we had filed an appeal, my client still has made steps as best he can to make good on the payments. And he's made payments of $2,900 in total. And my respectful submission to the court would be that while he has a balance of $2,100, if the court is with me in my arguments, that would effectively stop any further payment from being made.
Well, I mean, it's not a matter for me to consider what he's paid or not paid. I just need to consider the principle.
No, of course,
Whether or not he was sentenced.
appropriately or not.
Yeah.
But if the court was to take the view, and I just, for the value of the court and just administration, if the court was with me in my argument and said, well, yes, I think that $2,500 is appropriate, I'm just letting the court know what's been paid. If the court was with me and said, well, in the circumstances, I would go with $3,000, I'm letting the court know what's been paid. And that was just the value proposition of that information.
Thank you.
So my lady, unless there's a particular area that you would like me to address you on further, I think that pretty much encapsulates the submission that I wish to bring to the court. And a summary that I hope that the court is with me and would allow this appeal.
All right, let me just make a note. So under head 5, for the first offense on a summary offense, the maximum sentence would have been by way of a fine, $3,000, yes?
Yes, my lady. I guess arguably what I'm saying is that I don't know how quickly or how things would work with refunds, but having paid $2,900 before the court.
I think you can have those discussions with the registrar, Mr.
Got it.
Daniels. I'm
Got it.
more concerned, obviously, with the principal.
Principles, yes.
Tell me, so do you make any complaint that the magistrate had acted beyond the scope of his powers to order a $5,000 fine? Because effectively that's what
Yes,
he did.
yes, my lady.
When the maximum sentence by way of fine is $3,000, is that effectively?
Yes,
Okay,
yes, my lady. Just to buttress the point that I appreciate the magistrate had said 2,500 times 2. Had he
I
said
mean, really
2,000,
what he's done is he's said $5,000 because
yes,
the principle that we're relying on in Noble is that you're looking at the single accident. We're not
correct,
talking about 2 different accidents.
correct,
And so for having caused this one accident, which is the factual underbelly of the grievous bodily harm caused by careless driving, the first offense calls for no more than $3,000 by way of fine. And
Yes.
the magistrate imposed $5,000
yes,
as if he had 2 offenses before him. He may have had
Correct.
2 charges, but really there's one offense, even though
that's correct, my lady.
there's 2 charges because it's one accident.
Yes,
Okay.
absolutely. Excuse me.
So Mr. Rogers, can you pick up from that very point, please?
Yes.
I don't know if you want to go back to the disqualification, but we can do that afterwards. I would be greatly assisted if you can tell me what the Crown's position is on the principle that one accident, as a matter of legal principle, really amounts to the one offense when you're looking at how to sentence under the Traffic Offenses Penalties Act.
Yes, my lady.
It's good for
Good.
disqualification, it's good for a fine, it's good for any period of imprisonment. You're looking at really and truly a first offense.
Yes, my lady. So the position in Noble, I would submit, is not of as much benefit in the current case because Noble was a case which involved multiple deaths, from which a period of imprisonment was given. The period of imprisonment, which
Multiple
was
deaths from a single accident.
from a single accident, my lady. Yes, and the period of imprisonment which was given was much higher than the maximum sentence which the appellant in Noble could have received. The maximum sentence that this defendant could have received in this case was one of 3 years imprisonment as well as $3,000 fine.
Right.
So when a period or when a fine has been given, as it did in this case, even though it is more than the fine, if a fine alone was given, it is not more than the maximum sentence. We would submit that the maximum sentence which could have been received is one of 3 years imprisonment.
No,
as
no,
well as
sorry, I'm confused. Mr. Rogers, just dealing specifically with the fine. Am I reading it correctly that the maximum fine for a first offense is $3,000?
Yes, my lady.
And does the Crown accept that, notwithstanding the two separate charges, collectively they should be treated as a first offense because it was one accident?
Mm, Yes, my lady.
I mean, I can see your trepidation. I don't want you to feel, I'm certainly not trying to urge you into a corner that you don't wish to stand in, but I have to understand what the Crown's response is, because that's the argument that Mr. Daniels is relying on. His argument effectively is this is a first offense. And the only reason, as I understood it from you also, when we were looking at disqualification, the only reason we have two separate offenses on the information is not to give any sort of misguided notion that there is more than one offense for the purpose of sentencing under the Act, but it's only to give proper illustration to the different injuries suffered by the pillion passenger and the rider of the complainant vehicle.
Yes, my lady. My lady,
Because I mean, it would seem to me, and I obviously speak provisionally, who knows what view I will settle on ultimately, but it would seem to me that if you accept, when it comes to the point made about disqualification, that the single accident should be treated as a first offense under the Traffic Offenses Penalty Act. I mean, maybe that's not your argument. I'll certainly let you clarify for me, but I understood you to be accepting that I would be treating that one accident as a first offense. And I would be doing that because there was one accident.
that in relation to the disqualification, my lady, that is not the Crown's position.
Okay, you rely on Section 6.
Yes, my lady.
And you say Section 6 gives a special treatment when it comes to disqualification,
Yes, my lady.
a special
And that-
application of okay, go on.
Yes, my lady. And that the disqualification must start from the date of conviction. So if, let's say there were two offenses committed on two separate days, but they were both brought on the same date, the disqualification period for both of those offenses would start on the same date because of Section 6, which says that any disqualification period must start on the date of conviction. So notwithstanding that normally in circumstances where you do have two offenses committed on separate days, they will be consecutive. In relation to the disqualification period only, Section 6 provides that the disqualification period starts on the date of conviction.
I see. So your argument then is going back to disqualification. Suppose for a moment that an accused person is faced with the allegation of having gotten on their motorbike and carelessly collided into a vehicle in Hamilton, having caused serious or grievous bodily harm, gets back onto that bike and does the same thing in Warwick, Southampton, Somerset, and then all the way back down to St. George's and Smith's, and commits the same offense on those multiple occasions on the 25th of January. That's a random date. The only sentencing powers available to the magistrate for those, let's say they were amounted to 8 to 10 different collisions, could be 2 years imprisonment concurrently.
2 years disqualification.
Sorry, disqualification.
My lady, I think that it is no, is what I'll say is the short answer, because the disqualification takes place from the date of conviction. So, taking your example, if someone did commit
They were charged jointly, if those offenses were jointly charged.
My lady, even if those offenses were not jointly charged, so if one was charged for the 25th of January, and
No,
then
suppose they were jointly charged. I want you to suppose that an argument is made that, listen, there is some proximity in both time and locality. And that is the basis for him to be, for all those charges to come in one information, so that the convictions are imposed on the same date.
yes, then the period of disqualification would start on that date.
And the magistrate would not be able to pass consecutive sentences.
Yes, my lady, that's what I'm saying. So even if the offenses were committed on different days, so let's say it's one committed on the 25th of January, and then the defendant commits the same offense on the 26th of January, what often happens is that someone knows they have multiple traffic offenses, so they do bring them on the same date. Those two offenses, the period of disqualification would both start on the date of conviction. Rather they were committed on the same date, different dates, the period of disqualification itself starts from the date of conviction. So I would say that Section 6 prevents a consecutive running of the disqualification period, because it says that the disqualification period must start on the date of conviction.
So standing beside someone else who has only caused one accident, they would both stand to be disqualified for the same period of time. If you have defendant A who has been convicted for multiple offenses of careless driving and causing grievous bodily harm, all of which are joined in the same information, that person A or defendant A stands to be disqualified for 2 years in the same way. And even though they're 2 years perhaps on the various offenses, but they're 2 years run concurrently, that would be no different from the effect of the sentence on someone who had only caused grievous bodily harm in one accident, where the magistrate finds that 2 years is also appropriate for that person, but that person now is also serving 2 years of disqualification.
Yes, my lady.
That's really
It's not
unsatisfactory, isn't it?
No, it's not. But that's the way that the legislation is drafted. I would tie it. It's not satisfactory, but that is the draft in that that the legislation has in our view. It's difficult to see a way around that, given the imperative which it says the disqualification shall commence on the date of conviction.
Can you take me, do we have statutory provisions on the passing of consecutive sentences? Is that in section 55 of the criminal code or somewhere in that part of the code?
My lady, it does not appear. I think that the closest we have is section 57,
Okay,
determination of sentence.
thank you. I've just received the case of Crown and Costco. I think Mr. Daniels, you sent that?
I did, my lady. That was a case that was referenced in that paragraph 34 of my submissions. So it was previously cited. And just to go over Costco, that was a case where, just using the analogy that your ladyship had asked.
No, I don't want you to take me on track. I just want to note that I have it. I'll come
Yep,
back to
thank
that.
you, my lady.
Sorry, I'm just,
Thank you.
I don't want to take Mr. Rogers off his thought process. You were asking me to look at section 57, Mr. Rogers?
Yes, my lady. I believe that is. I don't see a specific section that deals with consecutive, but this section does deal with determination of sentence, and it does deal with consecutive where a default in relation to a fine. If we look at subsection 3, when accused is sentenced while serving a term of imprisonment for a prior offense, and a term of imprisonment rather in default of payment of a fine or otherwise is imposed, is convicted of an offense punishable by both a fine and imprisonment, and both are imposed, or is convicted of more offenses than one, and more than one fine is imposed, terms of imprisonment for respective offenses are imposed, or a term of imprisonment is imposed in respect of one offense and a fine is imposed in respect of another offense, the court that sentences the accused may direct that the terms of imprisonment that are imposed rather in default of payment of a fine or otherwise be served consecutively. So actually that does speak to further
Whether
reading.
in default of payment of a fine or otherwise be served consecutively. I mean, of course, we're talking about the court's powers in relation to a sentence of imprisonment. Let's see, commencement of sentence. Okay, let me ask you this. I have to say it's not yet obvious to me what the correct position is in terms of how to treat one accident. for the purpose of sentencing under the Traffic Offenses Penalties Act. So let me just, a moment, come back to a point that troubles me. So you say, Mr. Rogers, that the information should be treated as someone who is serving as a first offender or a second offender, because there are two different charges.
My lady, I think that we would have to accept that it would be a first offender.
Okay.
Given that it is arising from one run accident. However, we will also submit that in looking to sentence, the court has to consider a sentence which is proportionate to the gravity of the offenses as well as the degree of responsibility of the offender. And we can see at page 23 of the record, the court took a particular view in relation to this offense. And he says this offense resulted in very serious injuries to two persons and extensive damage to vehicles. Both you and the complainants are lucky no one was killed. It could have happened, in which case you would have been facing a more grave charge before the court. You're entitled to defend your case as you did, but as I found you guilty, there is no credit for that. The evidence I found was strong, particularly given your responsible first tax. I'm going to impose a mandatory disqualification, as well as he says the fine of $2,500 times two. So, my
So
lady,
he's treated it as two offenses,
yes, my lady.
but you've just accepted that this is, he's a first offender.
Yes.
I mean, can those two positions cohabit?
My lady, I do believe so,
How?
because
When I go to the Traffic Offenses Penalties Act, am I going under someone who's committed it as a first offense, or am I going under two offense as a second offense? I mean, it's really a difficult position for you to defend, Mr. Rogers, because you're forced to make a determination for the purpose of sentencing under the Traffic Offenses Penalties Act. You have to decide whether or not this is someone who has committed it as a first offense or a second offense. That's how the legislation is structured. And if you accept that he's committed the offense as a first offense, then you are bound by whatever the maximum penalties are. The maximum penalty is $3,000 by way of fine, which means that a $5,000 fine effectively is what that is for first offense.
yes, my lady. I do think that I still have to concede that it cannot be taken as a second offense, because prior to the convictions, he would not have been convicted of a
It
similar.
sounds like a sensible position to take. It's difficult. I think that is a sensible approach. I do. It's nearly inconceivable how you might describe Mr. Creary's category as a person who's a second offender
Yes, my lady.
after only one accident.
Yes, my lady.
And you wouldn't, sorry, just to, so that you know the fullness of what you need to address me on. it would be incredibly perverse in approach for the court to look at the head of first offense for the purpose of a fine, but second of offense or first offense for the purpose of, yes, I think I was right, the purpose of a fine, but second offense for the purpose of disqualification. I'm going to consistently look at the head that deals with the first offender.
Yes, my lady. Given that position, my lady, I would still submit that the court, the learned magistrate, at sentencing did take a very strong view in relation to the offense itself, as well as the injuries, and would submit that the maximum fine of $3,000 would be appropriate. And I do see how it will be difficult to argue that the fine of $5,000 was appropriate, considering that we are looking at it as a first offense. But I do say that with the strong words that the magistrate had, that the maximum sentence should be or should have been imposed.
So this is a case that you say warrants the maximum sentences in relation to disqualification and a fine. In
relation to the fine, yes, my lady, the disqualification is an obligatory disqualification
Right.
of 2 years.
Okay. Now, I'm not sure whether or not there's any real contention between both sides at this point, because Mr. Daniels has invited the court to settle on a sentence which will be, I guess, close to the maximum of 3,000. You would accept a $3,000 fine is appropriate, Mr. Daniels?
I would accept that. And the reason why I accept that, my lady, to be clear for the benefit of the record, is that notwithstanding that there is effectively one accident, there still were 2 people that were significantly injured.
Mm-hmm.
And so, for example, if this was a case where defendant had gone to trial, was unsuccessful, but only one person was injured, I might have tried to persuade the court that $2,500 would be appropriate. But with the cap in place of $3,000, I couldn't complain. And considering for what value it holds, unbeknownst to me up until today, my client has paid $2,900. I don't have a written instruction from the client, but I would think that there's no recourse at this stage to try and claw back what's been paid into the court. Whether the court felt a need to cap it at $3,000 and request the extra 100, I'm sure my client will do everything and abide by all court orders accordingly. But I wouldn't say that it's excessive to impose a higher end of the fine, having proceeded to trial with the final judgment that the court concluded, having heard all of the evidence down below. But the fundamental premise of being charged twice when there are caps awful, and it's been properly conceded by the Crown in relation to disqualification, and I now think in relation to the fine as well.
So there's no real contention between the Crown and the defense, or the, I'm saying the Crown and the defense, but really the appellant and the respondent in terms of the appeal being allowed to the extent that the disqualification period is reduced to a total of 2 years. And the fine is reduced from the total sum of $5,000 to the reduced sum of $3,000. Am I correct in understanding that to be the position?
Yes, my lady.
Okay. Well, I think I ought to allow the appeal in those terms. I wonder if I should all the same give written reasons. It seems to me that I probably should.
I think I would welcome it, my lady, in all the circumstances.
I mean, they're likely to be short, but I think it's certainly my consistent approach to these appeals in any event. But I will go ahead and I'm going to allow the appeal to the extent, as I've just outlined, that the period of disqualification shall now be for the period of 2 years, and the fine shall be reduced from the total of $5,000 to $3,000. And I'm going to follow that up with written reasons.
I'm grateful. Thank you, my lady.
I'm grateful, my lady.
All right, unless there's anything further, we can adjourn. Thank you very much. Thank you.
Thank you. Have a great day.